Good afternoon, everyone. I welcome you all to the 70th session of Zentax Talks. Firstly, I would like to thank you all for your continuous support for all our webinars and Zentax Talk sessions. Today, we are going to see one interesting area in GST, which is appeals under GST. In today's webinar, we will discuss what are all the provisions which relates to appeals under GST, and also the practical case scenarios, and what are all the remedies available for appeal in GST. First, before starting the appeals, let us first see what are all the pre-proceedings which leads to appeal in a short manner. When we talk about pre-show cause notice proceedings, we may have a scrutiny of returns, or audit, or inspection, or search, or test purchases, or inspection during movement of goods, or these proceedings can also be initiated against an unregistered persons. So all these pre-scrutiny or pre-SCN proceedings may lead to SCN related proceedings. During the time of SCN related proceedings, intimation of liability will be issued in Form DRC-01A under Section 142(1A) of the Act, followed by a detailed summary of show cause notice in Form DRC-01 with detailed annexures will be issued to the respective person. So these are all the pre-SCN proceedings and SCN proceedings. And during the stage of show cause notice, the taxpayer or the concerned person will be given an opportunity to provide their reply, and also to substantiate their reply using documentary evidences. The proper officer will verify our reply and scrutinize, and thereafter the officer will decide whether to levy demand or to drop such proceedings. So the next stage after the show cause notice will be the order. Such order will be issued under Section 73 or 74 of the CGST Act. Such order will be issued in Form DRC-07. Such order will also have a detailed summary of such orders. In some special cases, the assessment of non-filers or summary assessment may also lead to these appeal proceedings in GST. So once we receive this order, what are all the remedies available to a taxpayer? The first stage is the first appeal. This first appeal will be filed with the department. These appeal provisions are given in Section 107 of the CGST Act. This appeal will be filed with Deputy Commissioner Appeals, or Additional Commissioner Appeals, or Commissioner Appeals. Once the appeal is submitted, after that proper officer will give us a personal hearing opportunity, and he will also verify all our submissions. In case the officer has accepted our claims, then he will drop such order, or else the next stage of proceedings will happen. During that proceedings, second appeal has to be filed with GST Tribunal. These provisions are given in Section 112 of the CGST Act. This GST Tribunal is the penultimate remedy available. Thereafter, the taxpayer has to go only to the High Court or Supreme Court. However, while taking proceedings to High Court or Supreme Court, there can be we cannot state against the facts of the case. We can only go to High Court or Supreme Court when there is any question of law, or when there is any violation of principles of natural justice. To summarize the above, the appeal and revision proceeding provisions under GST will be: first appeal will be filed to Appellate Authority. In case of revision by the revisional authority, that may also be undertaken. Or otherwise, the next stage is the second appeal to Appellate Tribunal. The third procedure is appeal to High Court, and the final one is appeal to Supreme Court. Now we will see what are all the remedies available against any order or decision. The first remedy is obviously appeal. The appeal can be made to a made to correct. Appeal can involve rehearing on questions of law as well as on facts of the case. This appeal can be filed against the order to question the validity of the law as well as to present the facts of the case also. The next remedy available is the revision. Revision involves a superior authority examining the legality of an order by a subordinate authority. That is, the revision will be done by the superior authority. He will examine the legality of the order passed by his subordinate authority. Revision can be made when the case has already been decided. Revision can involve cases like erroneous inference or non-exercise or improper jurisdictional exercise. Another remedy available is the rectification of order. In this rectification of order, this rectification order will be passed by the same authority who has passed the original order. Such order can be rectified if there is any mistake or error which is apparent from the records of the case. Now we will see what is rectification of order under GST in a detailed manner. Section 161 of the CGST Act provides for rectification of errors apparent on the face of record. We will see what is given in the Act. Without prejudice to the provisions of Section 160 and notwithstanding anything contained in any other provisions of this Act, any authority who has passed or issued any decision or order or notice or certificate or any other document may rectify any error which is apparent on the face of record in such decision or order or notice or certificate or any other document, either on its own motion or where such error is brought to its notice by any officer appointed under this Act or any officer appointed under SGST Act or any officer appointed under UT GST Act, or by the affected person within a period of 3 months from the date of issue of such decision or order or notice or certificate or any other document as the case may be. From this, we need to clearly note that this rectification under GST can be done by the officer himself or by the affected person. That is, the affected person can make an application within a period of 3 months from the date of such order. So within 3 months, the affected person or concerned person, they can file for rectification of order and they can get their order rectified. This rectification application can be done through online mode. Further, this section provides that no rectification shall be done after a period of 6 months from the date of issue of such decision or order or notice or certificate or any other document. The officer cannot rectify their order after a period of 6 months from the date of issue of such decision. Provided further that the said period of 6 months shall not apply in cases where the rectification is purely in the nature of correction of a clerical or an arithmetical error arising from any accidental slip or omission. This 6 months period shall not apply to the officer in case the nature of correction is any clerical or arithmetical error. Also, such rectification adversely, if any such rectification has adversely affected any person, the principle of natural justice should be followed by the authority while carrying out such rectification. Moving on, now we will see the appeals and what are all the provisions given in section 107 of the CGST Act. This section 107 subsection 1 has provided regarding the appeal, that is, any person aggrieved by any decision or order passed under this Act or the SGST Act or UT GST Act by an adjudicating authority may appeal to such appellate authority as may be prescribed within a period of 3 months from the date on which such decision or order is communicated to such person. From this section, we can clearly understand that any person aggrieved by any decision or order can file for appeal. So here they didn't mention only registered person can go for appeal. Even unregistered person can also file an appeal. Such appeal should be filed within a period of 3 months from the date on which the order is communicated. The date here is the date of communication of the order, not the date on which such order is issued. So we need to be very careful in determining the time period within which we file the appeal. As we saw in the earlier section, they have given an appeal can be filed to the adjudicating authority. So who is this adjudicating authority? The definition of adjudicating authority is given in section 2, subsection 4 of the CGST Act, where they have said that adjudicating authority means any authority appointed or authorized to pass any order or decision under this act, but does not include Central Board of Indirect Taxes and Customs, Revisional Authority, the Authority for Advance Ruling, the Appellate Authority for Advance Ruling, the National Appellate Authority for Advance Ruling, the Appellate Authority, Appellate Tribunal, and the authorities referred in subsection 2 of section 171. Now we will see who can file an appeal under GST. As we saw from that section, it is clear any person who is aggrieved by any decision or order passed can file an appeal. Also, the Commissioner may, on his own motion or upon request from the Commissioner of State Tax or UT Tax, can also file an appeal. That is, the aggrieved person can file an appeal. Also, the department can also file an appeal. Now we will see what is the time period to file an appeal. In case if the appeal is filed by any person, then the normal time period is within 3 months from the date of communication of the order. However, there is a condonation of delay. That is, we can file the appeal with a further period of 1 month by submitting a condonation of delay. In case the appeal is by commissioner, that is by the department, then the time period, normal period will be 6 months from the date of communication of the order, with condonation of 1 month. However, we have to note that the condonation of delay will be accepted by the officer only if there is any proper reason for such delay. Moving on, we will see what is the appeal filed by the department. These provisions are given in subsection 2 and 3 of section 107. The Commissioner may, on his own motion or upon request from Commissioner of other state tax or union territory, call for and examine the records of any proceedings in which an adjudicating authority has passed any order or order under this act or SGST Act or UT GST Act, for the purpose of satisfying himself as to the legality or propriety of the said decision or order as may be. Here, the departmental officer may direct any officer or subordinate to him to apply for the appeal to the appellate authority within a period of 6 months from the date of communication of such order. The such authorized person that can make an application to the appellate authority. Such application shall be dealt with the appellate authority as if there was any appeal made against such decisions, and such authorized person shall represent the cases on behalf of the department also. Where to file this appeal? If any decision or order is passed by the adjudicating authority of CGST, then appeal is to be filed with Central GST Appellate Authority. If any decision or order is passed by adjudicating authority of SGST, then appeal has to be filed with State GST Appellate Authority. Appeal can be filed in both online and offline mode. Let us now continue. bar on jurisdiction of civil courts. Section 162 of the CGST Act has provided that save as provided in Section 117, that is appeal to High Court, and 118, appeal to Supreme Court, no courts, civil court shall have jurisdiction to deal with or decide any question arising from or relating to anything done or purported to be done under this Act. That is, the civil court does not have any power to deal or decide on any questions or any cases related to the GST Act. Next, we will see what is the pre-deposit to be paid for filing an appeal before the first appellate authority. Section 107, subsection 6 of the CGST Act has provided the amount of pre-deposit to be paid in case if we are admitting any amount, then 100% of the admitted tax, interest, fine, late fees and penalty has to be paid. That is, let us say for an example, if we are having total 5 issues in the order and we are admitting 2 issues and disputing other 3 issues, then with respect to the 2 issues, we need to pay 100% of the tax amount, interest and penalty. And for the balance disputed amount, 10% of the disputed tax should be paid as pre-deposit. However, there is a maximum limit of 20 crores. In case of any order demanding only penalty without involving any amount of tax, pre-deposit for such order shall be 10% of the penalty amount. This is a new amendment which is brought by this Finance Act. Next, we will see the basic aspects in drafting an appeal. While drafting an appeal, we should be very careful in stating the facts as well as the legal provisions. Firstly, we need to give a brief explanation about our business, that is the nature of constitution of our business and whether we are registered or not, and our registration details. And we need to present the facts of the case. We need to give the facts in a very detailed manner, and what are all the pre-proceedings which has happened before should also be explained clearly. Next is the legal grounds, including questioning constitutional validity of the provision. Reliance can be made against the judicial pronouncements from erstwhile laws also. That is, judicial pronouncements from central excise or service tax or VAT can also be incorporated in the legal grounds. We should also submit all relied upon documents as an annexure to our appeal. In case if we are filing the appeal after the period of 3 months, then we need to submit file a condonation of delay petition with valid substantiating evidences wherever applicable. In case if we require any personal hearing, then we should also mention in the appeal for the opportunity of personal hearing also. Once we have filed the appeal, what happens is the electronic liability register will be updated as stayed in the portal. That is, once we file the appeal, the balance amount will be stayed. That is, the recovery proceedings will not be initiated against such taxpayer. We can find in the electronic liability register that our appeal will be will be admitted, and it will be updated with the status as stayed. Adjournment of hearing. Adjournments will be allowed by the proper officer if there is any sufficient cause. That is, the appellate authority may, if there is any sufficient cause is shown at any stages of hearing, he will grant time to the parties or any of them and adjourn the hearing of the appeal. However, the maximum adjournment period allowed is only 3 times. No such adjournment shall be granted more than 3 times to a party during the hearing of the appeal. Once we file the appeal, the order will be passed by the first appellate authority. This order can be a demand order, or the officer may accept our claims and may also issue a drop order. So it depends on the facts and circumstances of the case. The section 107 subsection 11 of the CGST Act provides for the order issued by the first appellate authority. The appellate authority, after making such further inquiry as may be necessary, pass such order as it thinks just and proper, confirming, modifying, or annulling the decision or order appealed against, but shall not refer the case back to the adjudicating authority that passed the said decision or order. The appellate authority can only confirm or modify or annul the order. However, such officer cannot refer the case back to the adjudicating authority. Also, provided that an order enhancing any fee or penalty or fine in lieu of confiscation or confiscating goods of greater value or reducing the amount of refund or ITC shall not be passed unless the appellant has been given a reasonable opportunity of showing cause against the proposed order. That is, the appellate authority cannot enhance the demand amount more than the amount mentioned in the order, or they cannot reduce the amount of refund or ITC unless they have given a reasonable opportunity to the concerned person. Provided further that where the appellate authority is of the opinion that any tax has not been paid or short paid or erroneously refunded, or where ITC has been wrongfully availed or utilized, no order requiring the appellant to pay such tax or ITC shall be passed unless the appellant is given notice to show cause against the proposed order and the order is passed within the time limit specified under section 73 or 74 or 74A. That is, the appellate authority cannot require the appellant to pay an extra amount, that excess amount, they cannot issue demand for unless issue an order unless that issue is given in the show cause notice. Also, such order should be passed within the time limit specified in section 73 or 74. Section 107 subsection 13 tells that the appellate authority shall, wherever it is possible to do so, hear and decide every appeal within a period of 1 year from the date on which it is filed. Also, the issuance of order, if the issuance of order is stayed by any court or tribunal, the period of such stay shall be excluded in computing that period of 1 year. Communication of order by first appellate authority. In case the appellate authority is disposing the appeal, such appellate authority shall communicate the order passed by it to the appellant, respondent, and to the adjudicating authority. The copy of such order passed by the appellate authority shall be sent to the jurisdictional commissioner or the authority designated by him in this behalf, and the jurisdictional commissioner of state tax or commissioner of union territory tax or an authority designated by him in this behalf. So the copy of the order should be communicated to all the mentioned persons and also to the appellant. Moving on, the finality of order passed by the first appellate authority. Section 107 subsection 16 tells that every order passed shall be final and binding on all the parties of all the parties. So the order passed by the first appellate authority shall be final. However, such order can only be appealed against the GST appellate authority. Now we will see what are all the procedures involved in filing appeal to GST appellate authority. Once the order is passed by the adjudicating authority, then the next stage of appeal will be to the appellate authority. The time limit for filing the appeal before GST Appellate Authority is given in section 112 subsection 1. That is, the time limit is within 3 months from the date on which the order sought to be appealed against is communicated to the person preferring the appeal, or the due date as may be notified by the government on the recommendations of the council for filing appeal before the appellate tribunal under this act, whichever is later. So the time limit for filing appeal is 3 months from the date of the order, or as the date notified by the government, whichever is later. Since we know we have paid pre-deposit for filing the first appeal, should we pay pre-deposit again? The answer is yes. Pre-deposit should again be paid at the time of filing appeal before appellate authority. So in case we are admitting any amount at this stage, then 100% of the admitted tax amount, interest, fine, penalty, late fees should be paid, along with the 10% of disputed tax in addition to the pre-deposit paid before first appellate authority. That is, this 10% of the disputed tax should be paid in addition to the 10% of the disputed tax which we have paid during our first appeal. So this amount the maximum amount will be only 20 crores in this appeal also. In case of any order demanding penalty without involving any amount of tax, then the pre-deposit shall be 10% of the penalty amount in addition to the pre-deposit paid before the first appellate authority. Now we will see what are all the non-appealable decisions and orders. Section 121 of the CGST Act provides the scenarios where appeal cannot be filed against the orders. One such order is an order of the commissioner or other authority empowered to direct transfer of proceedings from one officer to other officer, or an order pertaining to the seizure or retention of books of accounts, register and other documents, or an order sanctioning prosecution under this act, or if any order is passed under section 80 of this act. So in these cases, against these orders and decisions, appeal cannot be filed. As we know, the appeal to High Court can be filed only when there is any question of law. So section 117 of the CGST Act provides any person aggrieved by any order passed by the state benches of the appellate tribunal may file an appeal to the High Court, and the High Court may admit such appeal if it is satisfied that the case involves a substantial question of law. So the High Court will admit such appeal only if it is satisfied that such case involves a substantial question of law, or in any other scenarios, the court will not agree or admit such appeal. The next stage is the next and final stage is the appeal to Supreme Court. The section 118 of the CGST Act provides an appeal shall lie to the Supreme Court from any order passed by the principal bench of the appellate tribunal, or from any judgment or order passed by the High Court in an appeal made under section 117 in any case which, on its own motion or on application made by or on behalf of the party aggrieved, immediately after passing of the judgment or order, the High Court certifies to be a fit one for appeal to the Supreme Court. So from this, it is clear that once the High Court certifies that this case is a fit one for appeal to Supreme Court, then in such scenarios, appeal can be made to Supreme Court. Now we will see the practical scenarios and case laws regarding the appeals under GST. Checking limitation. This is one very important step which we need to comply while if we receive any notices or order from GST department. That is, we need to check the time limits, whether the notice is properly issued within the time limits. If at all the notice is not issued within the time limit, then such notices can be disposed of by the courts. So now we will see what are all the time limits available for issue of notices. The time limit differs for if the notice is issued under 73 and 74. In case of section 73, for financial year 17-18, the time limit to issue an order shall be 3 years from the date of furnishing annual return. However, to issue order from 3 years, the SCN has to be issued at least 3 months prior to the time limit for issuance of order. So this is the table given for which clearly give distinction between section 73 and 74. For financial year 18-19, under section 73, the time limit has expired. For section for financial year 19-20 also, the time limit has expired. For 2021 also, the time limit has expired. However, for under section 74, the time limit to issue the order is 5 years from the due date of furnishing annual return. Hence, for financial year from financial year 18-19 to 2021, we can expect orders in the upcoming years, as the time limit for financial year 2018-19 is 31st December 2025, and for 19-20 is 31/3/2026, and for financial year 2021 is 28/2/2027. However, for issuing order within this time limit, an SCN has to be issued. That is, a notice has to be issued at least 6 months prior to such time limit for issuance of order. Contesting service of notices or order. We also need to check whether the notice or order which is given to us is given as per the provisions of section 169 of the CGST Act. That is, whether the notices or orders are served properly to the taxpayer has to be checked. So section 169 provides multivarious options to the proper officer to serve notice or order or summon or any other communication on the taxpayer. We will see what are all the various modes with which we can receive such orders, and whether it is allowed under GST or not. First is tendering, that is giving it directly or through a messenger to either one of the following persons. That is, such notices can be given to the addressee, taxable person, manager, authorized representative, advocate, tax practitioner, regular employee, or adult member of the family. In case of the notice or order is sent through registered post or speed post, it is allowed under GST. In case if it is sent through courier, there is no such condition whether it is allowed or not. If it is provided through email which was given at the time of registration, it is allowed. By publishing in online portal, it is allowed. By publishing in newspaper is allowed. Affixing at last known place of business or residence or at notice board of the proper officer, then it is also allowed. So these are all the proper modes for service of notices or orders. Now we will see one interesting case law regarding this contesting service of notice or order. In the case of Kashi Barton Bandar versus State of UP, the Allahabad High Court has held that. First, we will see what a small gist of this case. Here, the petitioner has challenged their cancellation of registration by the Assistant Commissioner. The petitioner says that there is no valid show cause notices was served to them before the cancellation. However, the department has claimed that they have sent the notices through email and affixation. That is, sticking notices at the premises. However, the petitioner has denied receiving any such emails, and they have also provided the inbox screenshot as proof. As we saw in section 169, they have prescribed specific modes of notice service. This affixation is allowed only as a last resort, which was not followed in this case. Here, the cancellation was made merely on presumption that business was closed without any actual evidences. Here, the Honorable High Court has held that there was a clear violation of the principles of natural justice because the petitioner they have not given any opportunity of personal hearing. The order also were passed merely on a prima facie opinion without any factual basis. The court has quashed the cancellation order. They also stated that the alternate remedies like appeal does not apply to this case as there is a blatant procedural violation. So this is one interesting case where the High Court has quashed such cancellation order because the notice or the order were not served properly to the taxpayer. We will see next case. In this case, that is Jindal Pipes Limited versus State of UP, Allahabad High Court 2020. The summary of this case is there was a vehicle interception in Kanpur and the goods were seized. The petitioner has paid such a tax amount and they have released the goods. However, against that payment, they have gone for appeal. The petitioner has filed the appeal on 6/3/2019. However, this appeal was dismissed because it is time barred. Appeal. The appeal was filed after the time limit. That is, the appellate authority has stated that this limitation period has started from 28/2019. This 28/2019 is the date in which that order or notice was served on the driver of the consignment. In this case, the Honorable High Court has said that serving the order on the driver, that is, who is not an aggrieved party, is not a valid service under the law. They have also referred to another case law where the service of such notice should be done to the consignor or consignee, not to the driver. Hence, the High Court has quashed the order, and they have ruled that limitation for appeal did not start from the date of service of the order to the driver. They have quashed this appeal and they have treated this appeal as a valid one, which is filed within the proper time. We will see another case. In the case of this is one very recent case. In the case of Deepa Traders versus the Deputy Commissioner State Tax 2024. Here the Deepa Traders has filed a writ petition. Because the appeal was rejected by the appellate authority due to a delay of 285 days in filing. The petitioner has claimed that although the orders were uploaded on the GST portal, they were not served physically, which leads to the delay. Here, the petitioner has said they have received the order on online portal, but however, they have not received the order physical copy, so they were not aware of the order reflecting in the GST portal. Hence, the petitioner has said that the absence of a hard copy has prevented timely awareness. So that is the reason of delay in filing this appeal. Here, the Honorable Madras High Court has acknowledged that the order was not acknowledged that even though the order was uploaded on the portal, no physical service was made to the petitioner. Hence, the court has decided that it is a reasonable cause for the delay in filing the appeal. So the delay in filing 285 days is condonable, and the court has set aside the appellate rejection order and directed that the appeal has to be heard on merits. Moving on to next case. This case relates to condonation of delay. In the case of Great Heights Developers LLP versus Additional Commissioner Office of the Commissioner of CGST and Central Excise 2024. This is also a recent case where the appeal is filed during the condonation period. The appellate authority has rejected the appeal, saying that the appeal is not filed within the timeline. However, the appellate authority does not have the power to condone delay beyond 120 days only. In this case, the period of delay is only around 24 days, and also the petitioner has provided a reasons to explain such, has given a reasonable has given a fair reason, and they have explained such delay. So the court has directed the appellate authority to receive and dispose of the appeal based on the merits of the case, and they have said that the condonation of delay shall be allowed. Next case is regarding limitation period in filing appeal. In the case of Ramaji Kirana Store, this is State of UP 2013, the Honorable Allahabad High Court. In this case, a notice was given to the person under Section 73, followed by a reminder notice. However, the reminder notice did not mention any details for personal hearing. That is, in the reminder notice, the date, time, or venue is given as not applicable. That is, the details were not clearly provided in the reminder notice. The assessment order was passed without giving any proper personal hearing opportunity to the petitioner. Here, the petitioner filed an appeal with a delay, and they have deposited 10% of the that is, they have deposited 10% of the disputed tax. However, this appeal was rejected because of the delay in filing the appeal without any detailed order showing application of mind. Here, the petitioner has argued that the violation of Section 75 subsection 4, that which mandates opportunity of personal hearing, and they have also mentioned some case laws. So the court has held that the court has accepted that no hearing was granted before passing the assessment order. So this is in violation of the Section 75(4) and principles of natural justice. Hence, the appellate authority also failed to properly consider the delay. There was no evidence of recent decision. So the petitioner's right to be heard was denied in this case at both assessment and appeal stages. So the court has quashed both the orders and provided relief to the appellant. Final case. This is one very recent case which has happened 2 weeks before. In this case, in Guru Kripa Steels versus State of Punjab Court, where the petitioner wants to file an appeal to GST Appellate Tribunal, and the petitioner has paid the pre-deposit for the said appeal, and the appellant was waiting for the constitution of GST Tribunal. However, the department has issued them a recovery notice. So in this case, the court has said that no recovery can be made after the pre-deposit payment, and the court has quashed the recovery notice. We are at the end of the session. We will wait for another 5 minutes. Please share your queries in the chat box. We will answer your queries shortly. We have one question from Mr. Ilam Pardi sir. The rectification filed against original order, rectification rejected from 6 months of original order. Now can we file appeal? Yes, sir, we can go for appeal. We have a case law also to support this, where the Madras High Court has given that the time limit to file an appeal should be considered from the date of the order rectification order. So we can go for appeal, sir. Can you share the PPT, please? Sir, we can share the PPT. Kindly mail us, sir. We will share in the mail. You can mail to solutions@zentaxclinic.com. Recently, we have been conducted with an surprise audit and issued with a notice for year 2018 to 2020 under section 74. Is that valid? Sir, kindly share us the notice. We can verify if it is issued within the time limit. How to get the pre-deposit refund from the department if GST appeal is in favor of taxpayer? Sir, we need to file the GST refund application. So on filing the application, we will get the refund, sir. Can we pay pre-deposit before formation of tribunal now? Then how to pay tribunal fee? Please explain, madam. Sir, we can pay the pre-deposit now itself, sir. Notices served to non-related person or not brought to the notice of concerned persons can be considered valid. Sir, notices can be issued to a third party also. So it depends on the cases, sir. If the person is related to us or if we have any due amount pending to them, then we need to pay such amount to the government. So it depends on the case, sir. We are at the end of the session. For further queries, kindly share your queries to our mail ID solutions@zentaxclinic.com. So thank you for all.